Welcome to Florida Appeals Journal. I'm Jennifer Carroll, and for today, we're going to talk about a very recent case out of the 4th District Court of Appeal. I believe it came out January 10th, 2024. It's called MCKEE versus CRESTLINE Hotels, 49 Florida Law Weekly, 124, D124. And it's all about vicarious liability. A very interesting case, and that's why I picked it for us to talk about on the journal today. That case involved tragic accident. Plaintiff and her husband were walking across the street. They were hit in the crosswalk, and the person sped off, so it was a hit and run. The driver was an employee of CRESTLINE, of the hotel, and he had left his job. He was a banquet manager, and he had left his job, but while he was driving, he was on his personal cell phone, making work-related calls, and basically following up with the event that they had just had, and was giving instructions, information regarding the banquet he had just left. This case, at the trial level, went for summary judgment. So in favor of employer on summary judgment as a matter of law. And plaintiff's position was the employer, the hotel, should be liable for all her damages, all her injuries, because this was an employee and he was doing something work-related while he was leaving his job. So employer should be responsible under the theory of vicarious liability. And the 4th disagreed. So let's look a little bit deeper into that and see, well, why is that? The rationale, I think, is going to be very important, especially in the age we're living in now, where we've got a lot of remote workers. So let's see, the basic holding by the appellate court was that just because he's leaving, and even though he's on his cell phone discussing work-related items, that is not enough to impose vicarious liability upon the employer. And the employer relied on the going and coming rule. So we're going to get into that. So fundamental principles in the case, and that's why I would recommend you reading this case if you do have a vicarious liability situation that you're dealing with, because it does address the fundamental principles of vicarious liability, as you know, respondeat superior, and the going and coming rule. So first, vicarious liability. An employer is vicariously liable for compensatory damages resulting from the negligent acts of employees committed within the scope of their employment, even if the employer is without fault. So that's the basic premise, right, of vicarious liability. So we all have a fundamental understanding of that. Now, and usually, whether an employee's acts were within the scope of employment is typically a question for the jury, a question of fact. So usually you wouldn't get to summary judgment on that, right? Okay. And I think this is important for people to understand. The doctrine of respondeat superior, which is vicarious liability, is based upon a public policy, right? That the victims injured by the negligence of an employee acting within the scope of their employment should be compensated, even if it means placing liability on, quote, an innocent employer. Again, that's a public policy rationale that justifies vicarious liability. Now, you have the coming and, well, it's the going, quote, going and coming rule. And under that rule, an employee who drives to and from work is not within the scope of employment, so as to impose liability on the employer for vicarious liability. So in this case, in the MCKEE case, the employer relied on the going and coming rule. All right, so what did the 4th District hold? They specifically held that the hotel employee in that case was not acting within the scope of his employment as a banquet manager when he struck the pedestrians who were crossing the street. He was driving in his personal vehicle. and thus the employer was not subject to vicarious liability for that employee's negligence. And this is despite the fact that employee was using personal cell phone at the time of the accident to give instructions regarding ongoing event or to otherwise further employer's interest. So realize the employee is on his personal cell phone in his personal vehicle. He's leaving work, but he is on the cell phone advancing the employer's interests, and that's very significant. But the court said it's going to be insufficient to impose liability. I want to go, because of the importance, I think this case is going to have, I think on future cases, I want to really delve a little bit deeper into the rationale. What the court held as to the first Sussman prong, is one of the key cases that's cited in the opinion. The trial court correctly reasoned that, quote, the act of using a personal cellular phone while driving home from work is not the kind of act the employee was hired to perform as a banquet manager. So the court said the allegedly tortious conduct in this case is the employee's negligent driving of his vehicle, not the conduct of providing instructions regarding the ongoing banquet. The relevant conduct at issue is using a cell phone for a work-related purpose while driving home from work. Neither driving nor using a personal cell phone while driving home was an integral part of the work the employee was hired to perform as a banquet manager. Quote, the facts of this case show that making work-related calls while driving was not central to the kind of work the employee performed as a banquet manager. Even if that employee was motivated to further his employer's interests when he placed the phone call to his employer, and there was at about 9:14 p.m., his decision to do so by using his personal cell phone while driving his personal vehicle on his way home was for his own convenience. The employee's conduct was not a risk incident to the enterprise of running a hotel. Rather, driving while using a cell phone was an aspect of his operation of his personal motor vehicle on his commute home. The cost of negligence in such circumstance should be imposed on the owner or operator of the vehicle, not the employer. So CRESTLINE, the hotel, had no ability to control how the employee used his cell phone in his personal car and did not hire him to drive or to perform the kind of work where using a cell phone while driving would be a practical necessity. That's the rationale. And I think the rationale is very significant in understanding that decision, that particular decision, and why there was, the court hold there was no liability on the part of the employer under those facts. So I recommend you taking a look at that case. Again, MCKEE versus CRESTLINE. It's out of the 4th District, January 10th, 2024, and that's 49 Florida Law Weekly D124. Again, good luck, and any questions, let us know. Thank you. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.